And welcome to the Evidence and Objections panel. My name is Keef Owens, and I am the Judge of Compensation Claims in the Port St. Lucie District. It's my pleasure to moderate and to introduce today's panel. Representing the perspective of the Judges of Compensation Claims, we have Judge Wilbur Anderson. Judge Anderson has served as a judge in two districts. From 1988 until 2003, he served in Jacksonville. Since 2013, he has served in Daytona Beach. Judge Anderson is a past president of the Florida Conference of Judges of Compensation Claims and a past chair of the Workers' Compensation Rules Committee of the Florida Bar. His experience also includes serving as an attorney in the Workers' Compensation Unit of the First District Court of Appeal. If you go to the website for the Office of Judges of Compensation Claims, you'll see a link on the left side named Orders Search. And here you can search all types of orders by type, by judge, and including final orders by keyword. I would encourage everyone to use this resource for research purposes. And in particular, I would encourage you to see what Judge Anderson has had to say on some of the thorny or legal issues we face in workers' compensation. I think you'll find his orders are some of the most well-reasoned and well-written you'll be able to find. Representing the perspective of employers, carriers, and servicing agents today, we have attorney David Rigell. Mr. Rigell is the managing partner of David R. Rigell and Associates, PA, in West Palm Beach. He has experience handling personal injury matters as evidenced by his board certification in civil trial law. More recently, and for the majority of his career, he's focused on workers' compensation law, and he has been board certified in workers' compensation law since 1994. And representing the perspective of claimants, we have attorney Jeff Friedman. Mr. Friedman is a partner with Vassallo, Bellata, Friedman, and Davis with offices in West Palm Beach and Stuart, Florida. Prior to securing his law degree, he worked as a workers' compensation adjuster. As an attorney, he initially represented employers and insurance companies, and for approximately the past 18 years, his practice has been primarily focused on representing injured workers in workers' compensation cases. Mr. Friedman is also board certified in workers' compensation law. And I'd like to point out both Mr. Rigell and Mr. Friedman are recipients of the Kenny Edwards Memorial Award. This honor is awarded to the workers' compensation attorney who best exemplifies the qualities of honesty, integrity, cordiality, good humor, high ethical standards, and advocacy tempered by a sense of humility. With that, I will turn it over to Mr. Friedman to begin with the role of pretrials and evidence and objections.
Thank you, Judge. Well, when I first started practicing as a lawyer, an attorney that I was working under would tell me, pay attention to the pretrial, pay attention. You can win and lose cases on the pretrial. And I never forgot that, and he was correct. Just to go through the formalities, the rules regarding pretrials is under 60Q-6.113. The biggest concerns to look at when you're looking at the pretrial, obviously you're looking at the evidence and the issues and defenses. The issues and defenses are extremely important. And one of the main reasons is under the rule, absent stipulation of the parties, you cannot add any new issues or defenses that were not previously raised that were ripe at the time. Additionally, you have to file responses to any issues or defenses as part of the pretrial, any affirmative defenses, or on the claimant side, a response or reply to the defenses raised. And one of the biggest ones is the 120-day rule. When we're dealing with estoppel, waiver arguments, you have to, if you're going to be raising 120-day rule as a basis for compensability, you have to include it in the pretrial. Now, there are some exceptions. The biggest one being there was a case, and I believe it was from Mike Weiner, where it was the Tico Energy versus Williams. And in that particular case, in the initial pretrial, 120-day rule was not raised. However, In the pretrial, it did stipulate that the parties agreed to that they could amend the pretrial at any time up to 30 days prior to the merit hearing. So the appellate court said, well, if they stipulated to amending it, then that supersedes the rule. So they did allow the 120-day rule argument to be made and found in favor of the claimant because of that. I, in my practice, always, or I never stipulate to allowing amendments other than for witnesses and exhibits, which is allowed under the rule up to 30 days prior. But as far as any other stipulations as to adding defenses, I would never agree to that because I don't want to be hit with a defense just prior to merit hearing and not have the ability to get discovery or respond to it as necessary. Likewise, objections to witnesses and to evidence and documentary evidence is very important. If someone lists a witness, you need to know what they're going to be testifying about. You need to know, are they going to be live? Are they going to be by phone or by deposition? So we need to know that ahead of time in order to fully prepare for your case. As far as any other objections, there's specific objections, as Mr. Rigell and I know, regarding any allegations of fraud. And I think it was Judge Owens, I think it was our first trial that was held with you. And there was an issue regarding specificity of a misrepresentation defense. So you have to raise an objection, but beyond that, and with any objections on the pretrial, if it's something that needs to be determined, we need to ask the court to rule on it. Because if not, then we get right before a merit hearing and it may be too late to address, or it may result in a continuance of the merit hearing. That is something that haven't had to do too much, but I don't know that very many people really do that or think about that. But back in the old days, we used to have live pretrials and deal with those types of objections. But now with everything just being submitted, you do have to make a specific request. As I believe all judges are handling it that way. There may be some that I'm unaware of, but all the judges that I deal with, unless we specifically request a ruling on an objection, it won't be handled until the merit hearing.
If I could chime in on that, Mr. Friedman, from my perspective, we may not get hundreds of pretrials per week, but we certainly get tens of pretrials per week. And it seems like it would be a waste of judicial resources to set a hearing upon review of a pretrial which has a single objection. One, because I think some attorneys are likely to make a laundry list out of the pretrial and list lots of evidence and witnesses that they never actually call or intend on calling. So that would be a frivolous hearing. And also, I think the parties would get probably frustrated with me if I set a hearing every time I saw an objection to pretrial, because that would effectively undermine the benefit of being able to do written pretrial stipulations.
Absolutely. No, it's up to the person raising the objection. So if you're raising an objection and you feel you need a ruling on it, then you just have to notify the court, and either it'll be ruled on or there may be a hearing, or however the judge wants to handle it. But the objecting party has to bring that to the court's attention to get a decision. As far as evidence, we have hearsay objections, authenticity objections. And we're going to get into that in more detail later. But once again, if you don't raise the objection, then this is a stipulation, and a lot of people don't pay enough attention, I don't think, to the pretrial. They just think it's a form to send in and you're filling it out, but it does have meaning. You are stipulating to these facts, you're stipulating to this evidence if you don't raise the objection. So you have to treat it as any other stipulation and be sure that everything's accurate, that you've raised everything that you need to raise. So if there's any question whatsoever, I always raise 120-day rule, waiver, estoppel, anything that may come up because you can't do it later. So taking time on the pretrial is extremely important, and it needs to be given more importance than I think a lot of people do.
Does anyone else have anything on pretrials?
I do, Your Honor.
Yes, sir.
Well, first of all, some of the folks, many of them probably, don't realize, because they were in kindergarten at the time when I started doing this, that we used to actually have, and Jeff alluded to this, I'm still twice his age, but he's been doing it a while. We used to have a 1 o'clock pretrial for a 1:30 merit hearing. We would literally walk into the court, and only then would you see, oh, he's got a voc expert. Who can I call? That really happened. That's the way it was done. Now with a 60Q, so much better. And frankly, it adds not only benefit, but danger. Because as Jeff points out, if you don't raise something timely, you very likely have waived it. Now, I just want to say something briefly on the point of timeliness, and I'm happy to hear the judge's comment on this, and Judge Owens already has to some extent. I would say this, only on key evidentiary points, and Jeff alluded to this, seek a ruling in advance of the hearing. I'm talking about make or break stuff, not was that objection leading or was it not leading? No, don't waste the court's time, nor would the court permit you to do so. But get a hearing on that, get a ruling on that. And I'm going to suggest that is advantageous both to the parties and to the process. First of all, to the parties, we have to do our pretrial memorandum. Wouldn't it be nice, wouldn't it be best to know that something really is going into evidence before I proceed to build a substantial portion of my argument thereon? Yes, it would. Also, it benefits the process. How many times have we shown up for a hearing at 9 a.m. and the claimant calls their first witness at 2 p.m.? Why? Because we're arguing about evidence for 4 hours. Now, some of that is almost always inevitable, but I would suggest not all of it. And some of this should be brought to the attention of the court sooner. And I would suggest that depending on the importance of the evidence and the pretrial ruling on it, it could even lead to a settlement of a case. Frankly, no need to go to trial if your or their evidence isn't coming in as they had hoped. So that's my point on timeliness. And I would like to ask the judges, do you entertain? I understand you can't entertain a hearing on every minor objection, but on something of major importance, as Jeff was alluding to, whether or not the specificity objection to the fraud defense, wouldn't it be best to have that decided before we actually show up for trial, before one party sees that their foundation has crumbled?
I would agree with that, Mr. Rigell. The issue that comes up, and the thing that I always like to remind the practitioners before me, is that an objection within a pretrial stipulation is not a substitute for a motion. I think there's a common misunderstanding in the bar that if you simply write in the pretrial that you have an objection to something, that is the same thing as actually asking the judge to rule on something. And so if something is going to be addressed prior to the final hearing, in my view, I think it should be properly filed as a motion. So if you object to something, then the appropriate thing to do is to file a pretrial motion to strike, to exclude, or something to that.
I agree with Judge Anderson. There's some issues which sometimes I will delay for the time of trial because the objection may be cured by testimony from one or more witnesses. So rather than have a trial before the trial, I delay those types of rulings until the time of trial, and sometimes don't rule until the time of the final order. But the lion's share, I think it's better to have the issue addressed before the final hearing, days or weeks before the final hearing, so the parties can go into the trial with eyes wide open and draft appropriate trial memos that address the actual issues that will be heard. Mr. Rigell, are there any objections or objection issues specific to documents?
There are, of course. Florida Rule of Civil Procedure 1.280B sets forth the general scope of discovery. We know this. Parties may obtain discovery regarding any matter A, not privileged, B, that is relevant to the subject matter of the claim. Now, the procedure for claiming a privilege, including the work product privilege, is set forth in 1.280 lowercase b6. I apologize for the typo. It's mine in the outline. It did not contain the lowercase b. But, and this is not a discussion of all the substantive privileges. If you want that, I commend Professor Earhart's Florida evidence treatise to you for that, and any other subject on the topic of evidence for that matter. But we are going to talk briefly about some procedural suggestions with regard to making these objections. First of all, if making a claim of privilege, including work product, the rule directs, the rule requires, it says shall prepare a privilege log. So you can't, or I should say you shouldn't, just object. You are obliged, you are obligated to prepare a privilege log following the requirements set forth in the rule and doing so. Now, I'm going to also make a suggestion here that we bait stamp our responses, not just in a privilege log. I'm going a little bit beyond the scope of the topic here, but in the response to a request to produce or in a ducis tecum for that matter, which I'll talk about later, because doing so, and hey, even I, in my cheapo copier, it will automatically bait stamp. Gone are the days of having to pay someone to sit there, and turn every page and turn and do that. Okay, it's all done electronically now. Let's do it so that when we are taking these depositions with these voluminous documents, we're not wasting so much time turning pages trying to find, is that on what? Where is that? Let's bait stamp it, save time, and do that. Now, with regard to the claim of privilege, do the privilege log, be specific, allow your opponent to reasonably determine if there is validity to the privilege or if it's necessary to call it up for hearing and let the judge rule on it. Now, going down to the motion for protective order. This is something that, frankly, in my experience, is rare and should be rarer. It should be more rare. And I'm going to go off script for a moment, but not off topic. Here's a place that we commonly see a motion for protective order filed. We are trying, I'm not by we, I just don't mean me, the parties trying to set a deposition of the opposing party's key witnesses or their claimant, employer, representative. And emails are exchanged, which are ignored or delayed, and it just takes a while. And finally, someone just, unilaterally sets a depo. Well, what happens then? Motion for protective order, didn't even coordinate the date with me. I'm going to suggest that in the vast majority of those cases, what the parties haven't done was the lawyers, by that I mean, have not picked up the phone to actually call the other lawyers. Hey, Dave, I really need this in order to do this, in order to know if I have a valid claim or if I have a valid defense, whatever. Actually speak to the lawyer. And here I'm speaking of going beyond the perfunctory and close please find, the good faith email, although technically sufficient. Here's my good faith for my motion for protective order. I would suggest here, especially in this case, and frankly, most cases, speaking with someone will resolve this. It will not be necessary. It will save you, your client, and the court time. A motion for protective order, according to the rule, is to protect against annoyance, embarrassment, oppression, or undue burden or expense. And yes, it can be used if someone unilaterally sets a depo and so forth and so on. The rule lists 8 additional considerations and purposes for a motion for protective order. read the rule to get all that. That's beyond the scope of this. I would just suggest finally on the point of motions for protective order, they should be a last resort, not a first choice. Make the call, obviate the need is my suggestion here. Now, moving on to responses to Ducis Tecum for depositions. How many times have I shown up at a deposition only then to realize, as the opposing counsel says, hey, do you have the documents requested in the Ducis Tecum? And then you're doing this. Okay, I'm not Catholic, but I'm making a confession. That's happened to me. Thankfully, it hasn't happened in a long time because even I, learn after a while, hey, that's not the best way to prepare, as in to not prepare. So what we now have a process, which I will suggest if you don't already have, develop a diary system whereby, all requests for production, I mean, hey, 30 days, everybody knows that. You got a diary system, you got a double diary system. Ducis Tecums tend not to be, certainly weren't for me, maybe I'm the only one in the whole Florida bar that never did this. We set the depot, but who's paying attention to this Ducis Tecum and making sure that the documents are either timely produced or timely objected to? Well, in my office, that would be no one. So again, happy to say that has changed, but I'm suggesting that you develop a process in your office so that before the deposition, well before the deposition, a pleading is actually filed, much like it is like a response to request to produce, because after all, a Ducis Tecum is a request to produce, to have and bring with you. This has a couple of obvious advantages. Number one, we've all probably shown up at a deposition and they produce nothing. And the person says, all right, well, without we're wasting our time here. We're going to reset. Give me the stuff. Entirely avoidable. Or the second scenario, you show up and you have a pile of stuff this high, at which point the interrogating attorney is like, oh my gosh, I had no idea. I can't possibly, we'll have to reset. I can't possibly. Avoid both. Respond early. Avoid delay. Okay, waiver. Sometimes when I get files from carriers, 30 days has already gone by. I've gotten a few emails or, letters or phone calls. Hey, listen, 30 days have gone by. All objections are waived. No, you got to produce everything. So is failure to timely object, assuming you have a valid objection, does that waive privileges in particular? The answer is no. That is a false contention. There are several DCA cases, recent third, there's fourth, there's second, one from December of just a couple months ago, which hold the initial failure to make a claim for privilege generally does not result in the waiver of the privilege. And the basis for this is the introductory language in 1.280, which says, when a party withholds information otherwise discoverable, claims for privilege, and when they're claiming privilege, they should prepare a privilege log. Well, privileged information is not, by definition, otherwise discoverable. So the failure to timely assert the privilege, according to the majority of the cases, does not always result in the waiver of the privilege. This court went on to hold, and I'm happy to give you the cites if you want to email me, so long as the privilege is asserted in a pleading before the actual disclosure of the protected information, you can still belatedly assert and frankly even prevail on the privilege. Now here I want to briefly talk about waiver in a couple of practical contexts, and that is communication with third parties. I'm going to get to the case of Smith v. Gardy a little bit later, which was the seminal case still on the greatest, I believe, judicial condemnation of an improper instruction by a lawyer to the witness. Don't answer the question, not answering the question. We'll get to that. However, there is only one JCC case which cited Smith v. Gardy, and it did so, Judge Lewis in 2011. I'm sorry, it was a DAL case, but Judge Langham no, I'm sorry about that. Sorry, judges, confused the initials, which are similar. Judge Langham held that the claimant attorney's assertion that his work product contained in a letter to his IME very well was work product, his thoughts, his mental impressions, and so forth, met the definition of work product, except that the privilege evaporated when he sent it to the third party, to the IME. So the lawyer improperly instructed the IME, not to produce, not to be deposed on, not to answer questions about, overruled, denied, depo reset at the expense of claimant counsel. So it can absolutely be waived. And here's a way, especially on the defense, you are in a discussion with your adjuster via email. The adjuster then on that email string asks the nurse case manager, hey, is that appointment set yet? Well, that might have just forwarded your work product over to, and then the claimant attorney has the right in most instances to get the nurse case manager's emails printed out. Oh my gosh, there's my opinion on the compensability of that condition, whether we've waived 120 or not. There it is, served up the claimant counsel. So be careful. These email strings, be very careful. You can waive the privilege both intentionally and quite unintentionally. Okay, so briefly, objecting to that which does not exist. What is that's a joke, right? No, it is not a joke. There's been lots of litigation over that. I will suggest to you that 440-32-3, which reads in part, paraphrasing, no pleading shall be interposed for any improper purpose or to cause unnecessary delay or to needlessly increase the cost of litigation. In that case, Phillips v. Leon County, the site is given, is but one example, I would suggest, of countless hours in which literally over the decades, millions of dollars have been expended in litigation quite unnecessarily, quite avoidably. Plaintiff counsel in that case set the deposition of EC's fee expert and attached to the notice a ducis tecum. Defense counsel took umbrage at that, responded by filing a motion for protective order asserting the work product privilege, quote, to the extent such documents exist, claiming that the existence of the documents, whether or not they existed, that's privileged. No privilege log was prepared. They have a hearing on the motion for protective order the day before the expert's depo is set, at which the EC counsel doubles down and claims on the record, these documents are, quote, absolutely privileged. The next day, the judge orders the production of a privilege log, which, by the way, still wasn't prepared. The next day at the deposition of the expert, only then does claimant counsel learned there are actually no documents protected by privilege. A motion for sanctions ensued, and that's what the appellate case is all about. And I'm not going to get into that. That's a separate day, a separate seminar. My suggestion is simply this. No privilege attaches to that which does not exist. Don't engage in hiding the ball. Like in this case, they were hiding whether or not a ball even existed. Let us not spend our time, or I dare say waste our and their and the court's time with litigating, objecting over, fighting over stuff that doesn't exist. If you believe you have a valid privilege, A, assert it properly, do a privilege log. B, fight like heck to uphold it, but don't fight like heck to prevent someone to know whether there's a reason to fight like heck. And that's the end of that.
Well, one of the ways to cure objections to documents may be the use of a records custodian deposition. Mr. Friedman, what needs to be considered with respect to records custodian depositions and workers' compensation matters?
All right, well, thank you, Judge. In workers' comp, the way that we have our system in the pretrial, it's not that often that we need a records custodian depo, and I emphasize the word need because I've had many times where I've had to sit through a records custodian depo where I've told counsel, provide me a copy of the records, let me know what you plan to submit. I'll most likely not object. Relating back to the pretrial, you list the records on the pretrial. I've had times where I would list carrier payout as an exhibit, and defense would object, and then on their exhibit list, what do they put? Carrier payout. So why are you objecting to my listing of it if you're listing it as well? it's again, as David was saying, it's unnecessary, and it's not really a valid basis to object. But in some instances, we do need it. If it's an unauthorized provider who's not producing or providing the records, or if counsel thinks that, because a lot of times with doctor's offices, they'll send the printed or the typed reports, but they won't send the intake form, or they won't send the DWC-25s or any other documents that they may have in their file. So the only way to get it may be a records custodian deposition. So sometimes they are necessary, but it's only if you can't get the complete records, or if you're questioning if it's the complete records. If there is an objection, a hearsay objection or a authenticity objection, then that's another reason to take the deposition. Now, as to authenticity, clearly a records custodian deposition, if done properly and you have the right person, would cure an authenticity objection. Bigger question is, would it also cure a hearsay objection? And in some instances it does, in some it doesn't. The main way that it would cure is if you're raising the business records exception to the hearsay rule. If it's truly a business record, though, it has to be a business record, and I've had this come up before, and I've had someone try to argue that some records in the employer in the employer's possession is a business record, but it had nothing to do with their business. It had to do with the workers' comp claim. That's not a business record. It has to be, and I won't, everybody can read the rule on that, but it has to be for the purpose of the business itself, not to document something that took place.
And if I could add, please be careful, because there are 4 magic questions or prongs, and I've been surprised to see how many times seasoned attorneys will ask 3 or 4 questions, and this is the 4th, and it's not a balancing test. There are 4 prongs and a statutory exception, so you gotta make sure you hit each one, even if you make a little checklist before your depo and tick them off as you ask them. But please be careful in that regard.
Absolutely, thank you, Judge. Now, what records should be included, and this is really a combination of records custodian depositions, but also pre-trial, kind of blending these two together. And I neglected to mention this earlier. When you're submitting records to the court, submit what you need to submit. I had a case not too long ago where it was a very narrow issue, and defense counsel sent 500 pages of records as one exhibit, and there were so many duplicates. It was really about 80 pages of records. They weren't in order. They were mixed up all over the place. And when I first saw it, I was like, that's not going to be too happy about that. And sure enough, the judge said, no, you need to resend this. Send me, one of each page, not duplicates. And I want it in some type of order, both by date and by provider, because it was doctors mixed together, dates all over the place. So, the judges don't have time to go sifting through all this. We need to provide them with the information that they need to make their decision, but we need to limit to what's necessary. So, and I've even had doctors' depositions where it's a new issue. That guy's been treating for 10 years, and I only attach the records that are at issue because it's unnecessary.
Hey, Jeff, I had something to add to that, just very quickly. Exactly to your point. put in only that which is absolutely necessary to sustain a claim or a defense. How many duplicates, lab reports, insurance billing pages, HIPAA forms does the JCC really need to see? And the answer is almost always 0 of those. And so I just wanted to ask the judges, this is a time to tell the entire, Florida bar, or those who are listening, how much evidence is well dumped on you? How often, how much, in situations like Jeff just described, 500 pages, duplicates, irrelevant stuff, sends it to you and basically says, hey, good luck with that, let us know what you think. What do you think? How often does this happen? And what do you want to say to the lawyers about doing that?
I'll jump in there. It does happen more often than I'd like. And what I'd like to tell everybody out there who's trying workers' compensation cases is try to put yourself in the judge's seat for just a minute. I think it was Henry Ford, who I guess was the Elon Musk of his day, who said the secret to success is to put yourself in the other guy's position. And so if you want to be successful in trying your case, whether you're on the employer carrier side or the claimant side, at some point you need to put yourself in the JCC's position and think about what you're asking the JCC to do. I think all too often, as a judge, we are confronted with what I would call a dump of documents, and we're supposed to sort it all out. And that's in cases where there are questions about discovery, as well as in cases about what should be in evidence at the final hearing. So put yourself in our position. We don't want to go through 500 pages of HIPAA releases and that sort of thing either. So think about that.
I agree. It does happen sporadically, occasionally. And I am convinced that there have been times where one side has put in 1,000 pages of medical records just to show what happened on a certain date. And I'm convinced that the attorney who proffered that or submitted in evidence did not look at every page, because when I looked through all 1,000 pages, there were more records that were contrary to the position submitted by that party. For example, claimant's attorney puts in 1,000 pages of hospital records to show the claimant went to the emergency room on the day of the accident. But those records go backwards 10 years and show that the claimant had been many times for the same type of complaint. So I would caution you to actually look at what you submit and make sure you want to submit that, because we do look at what you submit.
Absolutely. And lastly, with records custodian depositions, if it's an authorized treating provider, unless there's an objection on the pretrial, and unless you don't have all the records, there is zero need for records custodian deposition, because if we've listed on the pretrial and there's no objection, then there's a stipulation that the records are coming into evidence. So there's no need to have a records custodian deposition. It's just it's a waste of time and money. And some people they just think, well, I need these records in, so they set all these records custodian depositions, and I'll even contact opposing counsel and say, why? And if they say, well, I don't have this or that, okay, fine. But most of the time it gets canceled because I say, just send me what you want to put in, and I don't object, and then we don't need the deposition. So it's, we all have enough to do that we don't need extra work unnecessarily.
Judge Anderson, I know we've touched on this briefly before, but what considerations should be given when taking up objections to evidence prior to the final hearing, and how does that work logistically?
Well, thank you, Judge Owens. First of all, I'd like to make a distinction. We're talking about evidence in this portion of the seminar, and I think when we're talking about objections, we should distinguish between objections to evidence and objections to claims and defenses asserted in the pretrial stipulation. Again, I agree with Mr. Friedman and Mr. Rigell that the pretrial stipulation is very, very important. And so we need to go back and think about what it is that we're saying when we complete a pretrial stipulation. Subsection 4 of the form pretrial stipulation that almost everybody uses ask for the employee and the employer carrier to list all documentary evidence. And then there is a box for the other side to either agree or disagree and state the basis for the objection. And so it is very important, I think, if you're going to object to a document at the final hearing, that you will have stated your objection in the pretrial stipulation. And again, that goes back to being careful when you fill these things out. And I understand that maybe, 1 out of 50 pretrial stipulations is ever going to get seen at a final hearing because the cases are going to settle. But nevertheless, if you're going to trial on a case, you better have that pretrial stipulation filled out. So then the question becomes, how is that going to be addressed by the JCC? So again, talking about the point of view from the JCC, think about it this way. We're not, in general, going to be perusing every pretrial stipulation that gets filed to see if everything is filled out, the T's crossed and the I's dotted. So unless there is a motion to address something, it's going to get addressed at the beginning of the final hearing in all likelihood. So if it's something very important, if you've got a Daubert objection, for example, or something like that, then I would suggest that you give serious consideration to filing a pretrial motion and following the 60Q rule about how a motion is filed. Don't just say, well, Judge, I didn't agree or I objected in the pretrial, because at that point, you're at the final hearing. And if you've got, as Mr. Rigell said earlier, a make or break kind of evidentiary issue, then I think it's in your client's interest to bring that to the attention of the judge by a motion under 60Q 6.115. So that means you file the motion, you say in the motion, I've consulted and conferred with the other side, yet they're in disagreement. And then, at least in my district, I would probably schedule a hearing on that motion if it was something that the response indicated needed to be heard at a hearing. That's different, I think, from objections to claims and defenses in the pretrial. Claims and defenses in the pretrial, there are specificity requirements with that. That's not really the subject of our panel today, since we're talking about evidence. But I'll just mention as an aside, you do need to bring up those kinds of things too, if it's very important in a motion, and not just rely on your objection at the time of the final hearing. Having said all that, though, I will remind you that if the other side has objected in the pretrial stipulation to a piece of evidence and has stated the basis for that objection, I know at least in my district, I would consider that to be a timely objection, and I would not think that the other side could say, well, Judge, it wasn't brought up pre-trial, therefore it's been waived. I think if it's in there and it's an objection that's stated in the pre-trial, it doesn't result in a waiver if you don't bring it up in the motion. What it may result in, however, is a continuance. And that's because there's case law from the first DCA that has made it pretty clear that the whole objective of this workers' compensation world that we're living in is to get cases decided on the merits. And so most of the time, I think, if the JCC is going to err, the JCC is going to err on putting something off till all of the evidentiary issues can get sorted out and the case can be decided on the merits. I'll move into a couple of other issues with regard to objections before the JCC. Motions to admit medical records under 440-29-4, we all know what that is. Sometimes we forget what the actual statute says, and the statute says, if I can find it, all medical reports of authorized treating healthcare providers relating to the claimant and subject accident shall be received into evidence by the JCC upon proper motion. However, such records must be served on the opposing party at least 30 days before the final hearing. So the first thing to remember about evidence under 29.4 is that we're talking about medical records. And I think most of us who do workers' comp are aware of the case law that says, you know, a letter from counsel to the doctor is not necessarily a medical record, or a letter summarizing the doctor's opinions. But other than that, it needs to be a medical record, medical report. It has to be from an authorized treating healthcare provider. So we're not talking about IMEs. We're talking about authorized treating providers under 29.4. Often I will get motions to admit under 440 29.4 filed in a case, and the motion gets filed, and my practice is to diary it for a response if the motion says that there's either an objection or the other side hasn't responded. And if I don't get a response, then I will go ahead and enter the order granting that motion. But it is important to remember that from the judge's perspective, we want to know what the records are. And so if you're filing a motion and your motion to admit under 440 29.4 says all records of Dr. Smith, then the other side, if you're going to have an issue with certain records from Dr. Smith, needs to bring that up in the response. Otherwise, I'm probably going to just enter an order saying the motion is granted and the records of Dr. Smith are admitted into evidence. So think about that when you're on the other side of one of these motions. Even if you've got an authorized treating doctor, if you've got some particular record that you don't think qualifies under 440 29.4, you need to raise that in your response. DWC 25s, I think, qualify under medical reports because they are a report, even though they're used exclusively for workers' comp. They're asking for the doctor's opinions regarding MMI and that sort of thing. There are other ways, of course, to get medical records in evidence other than under 440 29.4. And of course, the easiest thing to do is to list them on your pretrial and have the other side agree. And if you do that, as we talked about before, as Mr. Friedman was saying, that you don't have to waste time with records custodian depositions and all of that. And again, from the judge's point of view, we don't like to see situations where one side or the other is making another party jump through unnecessary hoops. If there's no question these are the records, why in the world would you make the other side get a records custodian to validate the records? So again, we want to see these cases decided on the merits to the extent we can, and that's where we're going when we think about evidence in general, not for technicalities that are sort of gotcha techniques.
And thank you, Judge. Mr. Friedman, that actually dovetails nicely with our next topic, what medical records are admissible. Anything to add in that regard?
Yes, Judge, thank you. And let me just start off with what Judge Anderson mentioned. Some people they object because they can, not because they should. And that just, one, wastes time, and two, and the judges can speak to this, it creates more work for you and can be frustrating because you're wasting valuable time over something unnecessarily. And I had a hearing where counsel objected to submission of records from a specific doctor, and then the judge said, well, you've listed them on your pretrial exhibit list. Why are you objecting? And then we actually spent hours going over objections on things that we both had on our exhibit list. So object when you need to, not just because you can. But the records, as Judge Anderson mentioned, that are admissible, typed reports of the authorized treating physician, DWC 25s, records of unauthorized physicians are admissible for fact purposes only. The big question that may have been answered, I wasn't thrilled with, but is an IME report admissible without a doctor deposition? There was a case that came out in 2019, Blanco versus Creative Management Services, 281 Southern 3rd, 598, that found the IME report to be admissible under the business record exception. I was quite surprised at that decision. I haven't really heard much about it. I don't think too many people, and Judge Anderson and Judge Owens, I'll ask you, how often do you see someone submitting an IME report without taking their doctor's deposition?
Well, it's funny you bring that up. We have the good fortune every year at the Comp Convention of hearing from Professor Earhart, who speaks to the judges on issues of evidence. And it's probably been a couple years ago now, but he addressed that issue before the case came down. And he actually, I think he would agree with you, Mr. Friedman. He said that an IME report, by definition, is created in anticipation of litigation. So it's not going to be a record created in the normal course of a doctor's practice, say. So he came down the other way, but I have not had to face that issue as a judge.
I have not seen that presented before me as an issue with that particular case, but in general, when I get these kinds of cases, I say you've got to take the IME depo to get it.
Times I come across it are when someone's seeking an EMA and they base it on their IME as a report. And except for rare circumstances, I will object because I want to have the opportunity to depose the doctor and question the doctor, and maybe, and it doesn't happen too often, but every once in a while, an IME doctor may actually concede on a point and change their opinion and do away with any type of dispute that would allow for the EMA. So I would never feel comfortable just submitting a report because, if defense counsel was doing that and I take my doctor's deposition and I have my doctor address what's in the report, you don't have the counter testimony to support the IME doctor's opinions other than just what's in their written report. And I think it's important to have that testimony. So I don't know what's going to happen with that. I mean, that case is still out there, but I really haven't had that as an issue, thankfully. But as far as what is admissible, it's authorized treating healthcare provider, and I will mention as far as the motion to admit is healthcare providers, which is not limited to doctors. It is defined in 44013. Healthcare provider can be medical facilities and other types of medical providers, not just a doctor. So those are what's admissible, and again, only put in what you need. I can't stress that enough, because if defense counsel submits 1,000 pages of records, I need to review 1,000 pages of records, and I need to see what's in there. And sometimes I'll have to say, well, I agree, except for the questionnaire or the letter and things of that nature that are not reports. So I think for the most part, attorneys on both sides are reasonable, and we do, the proper thing and submit what is supposed to be submitted and not put in additional information.
Well, evidence is a very fertile ground for discussion and seminar, and we were pretty ambitious in our outline for today's seminar, but I can see that we literally have 5 minutes. So for that last 5 minutes, I'll turn to you, Judge Anderson, from a JCC's perspective. How should documents and depositions be offered into evidence?
Thank you, Judge Owens. I'll be very brief. I know we're coming to the end of our time. I'm going to return to the theme that I've tried to emphasize today, and that is, I think about it from the judge's perspective. As an attorney, you want to win your case. As an attorney, you want to be successful. So think about what you're doing in terms of what you're asking the JCC to do in the litigation. So when you're offering documents and deposition and evidence, these are things that you may take for granted. You may say you're being too basic, but I have to tell you, I've been doing this for a number of years, and it never ceases to amaze me how some of these things are overlooked by counsel, a lot of new counsel, but also experienced counsel. So these are just some basic things to remember. When you get to the hearing, make sure that the documents that you are offering are on the docket. So we're sitting here in our courtroom or in our hearing room, and we're looking at the computer screen with the docket pulled up, and the attorneys are in the room, and attorney A says, well, Judge, I want Dr. Smith's deposition and evidence. Well, okay, counsel, where is that deposition on the docket? And sometimes I will get sort of a blank look on counsel's face, and counsel will say, well, Judge, I'm not sure. I know we filed it a couple of weeks ago. Let me see where it is. And from my perspective, that gets a little frustrating because I've got the docket here, and it's not hard for counsel to have the docket. If they don't have it on their laptop or their tablet with them, maybe they could print it out, and that way it will just make things easier. So make sure it's on the docket, know the docket number. Keep in mind that because something is filed doesn't mean it's in evidence. And again, I hate to be beating a dead horse, and this may seem basic, but just because you have placed an item on the docket doesn't put it in evidence. So you need to move to put it in evidence. A couple other things, just because something was in evidence at a prior hearing doesn't mean it's automatically in evidence for the current hearing. So you got to bring that to the judge's attention. Discuss joint exhibits with opposing counsel in advance, because one of the first things I do when we start a final hearing is ask the attorneys, what exhibits do you want to offer? And we'll start with the joint exhibits. And a lot of times they will have said, well, we hadn't really thought about it, but sure, we can both agree that that's a joint exhibit. So it saves time if you discuss that in advance. Again, I won't continue to harp on it, but the pretrial is very important. Pay attention to the document and witness sections of the pretrial, because when we get to the final hearing, the JCC is going to be looking at the pretrial. Be prepared to address objections to admission at the beginning of the final hearing, and don't give us 600 pages of medical records that are unnecessary, because we don't want to have to look at them. Thank you, Judge Owens.
Thank you, Judge Anderson, and thank you, Attorney Friedman and Attorney Rigell. With that, we will conclude. I'd like to thank our panelists for their time and hard work in preparing this presentation, and we'd like to thank everyone viewing for their kind attention. Thank you very much.